Nagaland Sargar bra non-state civil service candidate ke IAS te contact koribole faisla loa upar Panchta State Service Association bra alag-alag Sargar offices aro institutions te October 14 bra 16 tak Pentown strike loa upar state cabinet bra aji meeting lushe. Minister for Power and Parliamentary Affairs KG Kenya Ragushege appointment to Sargar bra nutun trend introduce kura nahoy kintu purana Sargar bra practices kura mana lagase. KG Kenya bra assert krishage Sargar do family nishna function korea aro grievances takisha koile pehla mamla do solchaf koribole lage. Mamla over sabo nimide state cabinet bra subcommittee constitutes krishak kintu deputy chief minister pattern aro TR Ziliang bra spearhead koribo. Meeting day Frontier Nagaland Territory Authority Reservation Policy aro Indigenous issue uperbi kota korishe. Details saisabo.
Good evening. Thank you for making yourself available this evening. Today we had the state cabinet meeting and many long-awaited issues were deliberated. One of the first subjects we deliberated upon was, of course, the current agitation going on in the form of Pentown strike by our Kansina, NSS, Nida and the associates against the advertisement of the IS vacancy from the state government side, which used to be conferred to government servants, officers, with a breakup of some reservation for the state civil services sector and the other portion for the non-state civil service sector. So here a controversy has erupted very recently, and you must be keeping track of the reasons that they are putting forward to the government and all the actions that the state government has been resorting to in the exercise to fill the one vacancy, whichever is. I would like to take us back to the precedents which was set already since many decades ago, and try to refresh everybody's memory on the way how the vacancies arising in the IS induction used to be conferred to our officers. So roughly, we may say out of the 33% that falls vacant for the state governments, out of that 33%, there used to be something like a breakup of half and half, 7.5% or 7%, 8%, more for the civil service, state civil service cadres, and the remaining for the officers from the other services. So it is in this other services quota, that sector, where the controversy has arisen. From what has been deliberated by the cabinet today, thoroughly, inputs have come in from high officials, and legal opinions have been sought, and the state government have also gone into in-depth study on the nature of appointments made for vacancies falling in this sector. So what the cabinet has discovered or observed today is that this is not a new trend which the present government has introduced. Rather, the state cabinet, the government has adhered to the practices which were set as precedents by the previous governments. And that one vacancy which arises this time, there's a tussle on it that it should be reserved for officers who have been appointed through the NPSC, exclusively for those candidates whose entry point was through the Nagaland Public Service Commission only. Earlier, people were not clear about this, but on further scrutiny, it has been established that there were so many officers in decades past who were conferred the highest titled and inducted into this cadre, who were not NPSC entries. So the agitating party today are insisting to make the entry point a basis and the sole benchmark for an officer to qualify to be considered for induction to this highest cadre. The entry point should not be the basis on which this decision should be taken. Rather, as per the IS 1954 rules, which is clearly established back in 1954, they have already established certain laws and acts in the subsequent years, like in 1997 also. This is to do with the appointment by selection against the rule vis-a-vis the 1997 Act of IS. And also other rules that governs in the selection of the officers. It clearly states that the entry point is not the basis and should not be. Rather, whichever entry point they might have been inducted into the state services, what matters more and counts is their annual reports, service reports. We call it APRs. And their integrity, their loyalty, their ability, and their commitments and performance should be the criteria upon which they should be considered and qualified. There are other rules which also say that they should have served at least for a minimum period of 8 years in a substantive capacity, which I would say is in a gazetted post. Their records, their integrity should not be questionable. So if the selecting authorities are satisfied that they merit and they qualify to be inducted, then they are taken, they are proposed by the state government, And we have at our own level the state screening committees who sees to all these details whether they fulfill the criteria or not. And it is forwarded to the UPSC again at the center. And they in turn scrutinize and study, make their own observations on the recommendations of the state screening committees. And if there are no discrepancies and the persons fulfill these criteria, then only they are recommended for the induction of this IS cadre. So this is the procedure that we follow. And here, what actually went wrong was the appointing specifically to the 10th of March 2025's vacancy circular advertisement, where one of the points, perhaps point number 4, states that the person, the officer, should be a candidate who has entered through the NPSC, making that a rule, a condition. So here, what the cabinet have observed after thorough deliberation and interactions with officers is, unfortunately, certain procedures fell short of the actual way of bringing it to the cabinet and to the notice of especially the Chief Minister, who is the Minister in charge of PNR, Personal and Administrative. Here, our bureaucracy, I think, fell short of their required procedural duties and responsibilities when the matter was never brought to the table of the Chief Minister. And so he, in turn, was not made aware. And when it came to the cabinet, it was approved. It was approved for the circular to be advertised. But no sooner after it was circulated, it was found out that that particular number where the requisite qualification should be entry point to the NPSC should not have been a condition. Unfortunately, that figured in the requirements to propose the candidate or to forward the candidates. So eventually, after having detected the anomaly, it was revoked, cancelled, and another circular was advertised. So that is the point of contention where there are differences of opinion, and I think that led to the agitation which the party is now going for the second and third day. Unfortunately, they also should have brought it to the notice of the government as and when they felt that certain procedural lapses are being practiced over the years. But at no point of time, as far as we have the records, the practice of inducting officers from other services and not through the NPSC have also been entertained and were inducted in the past, was never opposed to and has never been brought to the notice of the cabinet nor the preceding governments also, even this government also. And all of a sudden, when the previous practice was being adhered to only, the realization might have dawned on some people that this should be discontinued, and without proper discussions decide, they have resorted to dictation, which is not well taken. We function as a family, so if there are any grievances, the government expect any party from anywhere to first try and resolve by pointing out these points and try to resolve it amicably instead of resorting to sudden agitations like this. But this has to be seen from the light of a government trying to exercise its discretions also. These are policy matters, and the executive, the bureaucracy alone, cannot make policy decisions. So if there is to be a shift in the practice, then it calls for a policy decision which only the cabinet is authorized to take. Unfortunately, all this could not be observed in time, and we have a situation here today. But despite all, whatever has been said and done, we hope for a peaceful resolution. Therefore, today, the cabinet has constituted a subcommittee, uprising spearheaded by our Deputy Chief Minister, Planning, and also the Deputy Chief Minister for Home, and with a few of us as members, including our Chief Secretary. We will be discussing, studying more on this aspect, and discussing and resolving this issue with Kansia and their partners shortly. Because our two deputy chief ministers, Mr. Patton and Mr. Tiazela, myself, and our Mr. Matsubu, with the chief secretary.
So is there any time frame for the committee to come up with its report?
No, but just before we dispersed, we wish to meet on the 20th of this month. So we hope we'll be able to meet with our organizations and resolve.
So you have pointed out that there have been lapses on the part of the bureaucrats in recruiting the cadre. So will the government take any action on those responsible, since it has put the whole state into a big problem?
No. The first advertisement, the 10th of March, had we gone by then, we would have violated the conventional practice which we were adhering to as a precedence, not barring those officers whose entry points were not through the FPSC. If that order did not bar those officers who did not enter through the FPSC, then it would have been fine. But when that order, when that advertisement was to be circulated, that file did not come up to the Chief Minister. And so it was not referred to the concerned persons also, and it was advertised. So after detecting that it barred that number 4 has barred those officers whose entry was not through NPSC from participating. Then that order was recalled, cancelled. So after that only the government have rectified that mistake, removed that, not only NPSC entries but like preceding years, or any officer of outstanding merit, integrity, ability, and APR, good APR, should be recorded. It was recirculated again.
So who is responsible for that mistake?
So, Cabinet felt that this was a bureaucratic procedural lapse. A bureaucratic procedural lapse. Because such matters should have gone up to the top man, the top office, that is the chief minister. And if so, then the cabinet would have, before it went out, been appraised that there are shortfalls, anomalies. Then, right from the beginning, that would not have happened. But it was re-advertised again on the 27th, perhaps, 27th of March. So after that, the objection started from the Kansia and others. And the first point that only NPSC entries should be qualified for this IS induction grew louder.
Okay, sir. One more question. There are rules in the service book preventing a government employee from holding protests against the government. So, how is the government viewing this thing?
Yeah, exactly. That is a pertinent point, and it came up for discussion today in the cabinet. But we would not be so harsh, because we feel that it is the people's government, and to the extent possible, we will be lenient in our dealings. So, after our initial discussion with them, we hope that all this will be resolved amicably.
So how many, you have said that in the past also there has been appointments or induction into IAS from the non-SCS leaders. So how many are there who have been appointed in the past?
As per records presented to us today in the cabinet, I think in the 80s, it started in the 70s, 80s, Mr. late R. K. V. Sisha, he was an agri-engineer. Yeah. Then we have Mr. T. Chen, who was also an agri-engineer and was the former retired director of agriculture, I believe. Then we have Dr. Chuba Temjen, and after him, we also have recently, in the 90s, I think already, Mr. Kong Liba. Kong Liba also in 1994, as late as 1994. Then we have our present principal secretary, Mr. Y. Kiketo Sema, also in 2010. Then Dr. Zasi Kulie Chusi, also in 2017-18. The resultant vacancies from the other services group. No? And the last was Mr. K.V. Sa Kense. So it is against his vacancy that this thing all started.
Okay, so far has anyone been inducted in that post, against that post? That vacant post?
That is the one in question now,
Yes.
which has been advertised. No. But the State Selection Committee, State Screening Committee, and the DOPT, that is the PNR in the state. since we're running out of time, the last date was 30th September. So I think they had set and recommended 5 names to the UPSC, shortlisting from 11 applicants.
So, are the protesting parties aware of these rules and regulations that have been put in place that you have already mentioned?
They must be aware. After all, they are into something which is guided strictly by rules and regulations. So they must adhere to the rules and regulations. Or there is some oversight and confusion which is straightened this whole place.
So I want to clarify something. So do you mean to say that the entry point may not necessarily be through NPSC?
Exactly.
For this particular post?
Because the unions law, the rules and regulations of 1997 and 1954 IS also, and DOPT guidelines does not say that they have to be through competitive, entry has to be through competitive exams. They have stressed on the importance of their later service life of integrity, proper APR and abilities.
So this practice is nationwide?
Yeah, it is nationwide, and as I said, even in our state also, for so many decades we have been practicing this.
So the state-specific rules and regulations on this matter is not there, or is there any
Oh,
such?
no. State goes by the guidelines which were already given to the state since many years back by the DOPT and IAS rules of 1954 and 1997. It appears that the center had been holding talks with the ENPO in August also and in September also. So I think the last was in Dimapur, sometime in August, early part of September. And you are aware, the state has already recommended, furnish our recommendations to the center after the center asks for the state's opinion on several points. On many of the points we have agreed, but there were certain areas where maybe reconsiderations should be made. So it was on those areas only the talks was centered around still. And to address those minutely, a subcommittee had been established by the PNAR department here in the state, along with the ENPO officials. So that's a new development, and we hope that that will address the crux of the matter that is holding us back from further progress.
So what is the crux of the matter?
That only they will do. The members from both the sides, the ENPO and the PNR. But roughly, from whatever was presented to us today, I think it centers around the dissolution of the FNTA's council, executive council, if it so happens. In such a case, who would recommend? Supposing there is a constitutional breakdown. One. And if it so happens that it is dissolved, who will be in charge, given the charge? Those are some areas which are there. And it is another thing is in the funding pattern, I suppose. And the third could be in the appointments of those different cadres in the region that is to be. But these are minor areas, and I think with more deliberation, it should be resolved. Should be resolved over time. So everything is moving smoothly, and we hope the center will be sincere and will not waste more time, but expedite the process.
So, was there any discussion on the reservation for that?
Yes, after the last memorandum and submissions made by the 5 tribes, that the tribal block-wise representatives should not be there, but be replaced by exclusively senior government officials. I think we have rectified that, as the proposal was to do with a senior former government official, IS. We are fortunate that our former development commissioner, Mr. Ramakrishna, has so kindly accepted the responsibility to spare the commission. And the others will be the ex-official members from the PNAR. Commissioner Secretary will be the member secretary. Then another will be from the Law and Justice Department. And the other will be from the Home of Commissioner. I think we have 4 or 5 members. The orders will be out in a day or two. With that, from the date that they are given the appointment orders, the 6 months start ticking.
Sir, last time in the month of August during the press conference, you had mentioned about the center suggesting creating a separate constitutional provision under 371 for FNTA. And you have also mentioned that the cabinet will be visiting daily to confirm that. So can you please update us on that?
Yeah. That came up for discussion today, in fact. And very specifically, we have discussed that. Members were concerned about the status of that position. But I could not be a part of the team which went to deliberate. But all those who went, headed by our chief minister and our 2 deputy chief ministers also, and quite a lot of members from the ENPO area, they have confirmed that the center does not mean to make any amendments for 371A. So they will be only having a chapter, a chapter in the form maybe of an ordinance or a state act, an act by our own state assembly, which will effect the changes necessary outside, which falls outside of the purview of the 371A. So in no way it is going back to the parliament. That has been confirmed.
Sir, a different topic, but you have raised this issue even in the assembly. You presented a statement regarding to these organizations, too many organizations that we have. So a lot of those organizations are being headed even by government employees. So can the government do anything to prevent such from taking place, since the government has initiated this even in the assembly, that there are too many organizations we have to cut down?
Of course, we cannot afford our employees spearheading NGO, non-government organizations,
And CSOs.
and CSOs. I think government rules prohibit anyone from taking up such positions. So we are not going to be lenient, and the choice is the person's own, but they cannot be doing two things at the same time. They are either that or this. And if they still defy government rules and violate government rules, then they will face severe repercussions and consequences.
So can the government give any order in this effect?
Well, I think it is understood, but if we detect any such, then notice will be served to them to decline, resign themselves, not to take up those positions. And so here there are cases where we are not aware of such instances. So if the public is aware, then it would do well, they would do well to bring it to the notice of the government immediately without wasting time.
Any CSOs and NGOs, any and all?
Yes. I think where rules does not permit, I think the government will not tolerate. That is where we are. How it is being referred to as a job reservation commission. That job, because it is not job alone. It involves so many things, so many aspects of life. So ultimately it has to be in consonance with the national census exercise that is taking place. So their terms of reference and the area of coverage is very wide, very wide. Not only employment, that is one. So that was rectified. Besides that, it should be okay. It should go down. One very pertinent issue that is confronting the state government and the people as a whole is the indigenous status. Earlier I was asking you if you've had some more discussions with the parties concerned. Today it did not come up in the cabinet because we were slated to meet the tribals yesterday, our tribal organizations, but our brothers from the eastern sector could not make it due to paucity of time and information. So it was postponed. It's postponed. But nevertheless, this issue has been doing the rounds, and over and all, the government has tried to assert our contention of what and who this indigenous status means and should be conferred to. So here, I think I have discussed this issue with you sometime back, but we want to again assert the position of the government that despite all said and done, whatever it may be, indigenous, that very word in the English dictionary, I don't know which ones you use. I use all three, Webster's, Chambers, and Oxford also. You may refer to it also, but it means people evolving naturally. It means the original owners and the original settlers who have been there, occupied it as occurrence naturally by evolution or by occupation and taking ownership of that particular land through, I would say, war, and have been occupying it ever since then as owners. So here there are no two interpretations or aspects of it. our people have to understand. Our land has undergone a lot of changes through ages, you see, centuries together. So the upper ridges have never fallen into the hands of any other power. It is the lowlands adjacent to the Assam state just now, which we have a lot of dispute with the government of Assam and us today. Here, there are different interpretations and versions that those, especially the 4 sub-tribes who have come to be a part of the scheduled tribes in our state, started claiming as indigenous citizens of the state. I think that is irrelevant. We have to understand. Among them, the Garos, they are mostly originated from present-day Nagaland, and Kacharis and Mikris. They are also more or less indigenous to Assam. And the Kukis, they are scattered around in many states in the northeast. We would not like to delve into their migrative route, which is further south maybe, but that's an entirely different topic. So when the state was formed, our yesteryear leaders were kind enough to accommodate many who have settled before 1963, the 1st of December, and granted permanent citizenship. Granting them that status need not necessarily mean that they have become indigenous. Not that anyone can transfer this status to another. It is just not possible. It cannot be awarded also, nor can it be transferred also. No, you just can't do it. This is something which has to do with history and settlement and ownership. So today, when we, the government, have said that in order to implement the register of indigenous inhabitants of Nagaland, because following that we have so many other social political problems, like granting of inner line permits, implementing it strictly, and also the indigenous certificates, along with it, the permanent residence certificate, and all others that is to do with the citizenship of the state. But for more than 60 years, we have not been strict on trying to differentiate and segregate who are indigenous, who are not. So today, the government of the day, under our Chief Minister, Dr. Rio, I think have resolved, in fact, that it is it's about time that we start getting down to the smallest details, so that the confusion among us will not be carried beyond our generation, our present day. And there will be clarity on all fronts, and it will be efficient for the government and the administration to start implementing the policies of the present day government. That is how, when the government had given time for the other tribes to have a revision of the enumeration, to write down the names and families of those who have settled here before 1963, instead of cooperating with the government and taking the opportunity they have started rebelling and challenging the government's order for enumeration of their citizens here in the state. So they have dragged the government to court and have said that their revision should not take place like other Naga tribes whose enumerations are not taking place. They too, there should be no enumeration. That is wrong. Whereas the other tribes of Nagaland do not have any family relations from outside of the state, excepting 1 or 2 cases. The general public are confined since time immemorial to the territorial jurisdiction of the present state. The other tribes, be it the Kukis, the Mikirs, the Kacharis, and the Garos, they are migrative in nature and they have percolated into Nagaland. So we want to know exactly our proper citizens prior to 1963. This, I think, should not be misunderstood. We are not discriminating, it is for clarity. And news have been doing around, you will know better. Your own counterparts in neighboring states, some have, I think, very vigorously tried to propagate the idea that the Mapu has been leased out for 99 years or so, and that it was the kingdom of Dima, the Kachari king, and all sort of things built upon that type of history. But we should be very clear about this. We will discuss more on this Sunday, hopefully, in the proper place of the Mapu. But history tells us, prior to 1228 AD, prior to 1228 AD, there was a Kachari kingdom there. But when the Ahoms came, all the way from Thailand, very strong, very good warriors, they came and then they completely took over the Kachari kingdom. So, ever since 1228, Kachari king, the monarch and their people have already abandoned their own kingdom and has gone to what you call today as North Kachar, NC, Afro. And from there on, they went further down to Kachar district, which is a part of Assam today, and have settled there. Some remnants might have slowly come again as laborers or whatever, and have come and settled down in the Mapu many centuries later. So after them, you see, 1228, then came the Ahoms after that. In 1228, then again our homes were defeated by the Burmese generals who came on the expedition, completely routed, and they took over. So our homes had to flee. They fled, and next, after the Burmese occupied, it was the English, the British soldiers who came again, and they defeated the Kukis, Burmese on all fronts. And after the Treaty of Yandabo, 1826, I think, they have surrendered and they went back. Burmese went back. It was during British India that Naga Hills was established in 1866. Prior to that, they had already established a subdivision. So we were already being administered partly by the Englishmen who first set foot in our land. And the administrative structure arrived then. So power keeps changing hands. You see, authority keeps changing. So in about 700 to 800 years plus, how can the occupants of those era come and say today that they are the indigenous citizens of them once taken? And that is completely irrelevant. It was once upon a time. But if you study history, in so many instances in the world, there were empires who have conquered different parts, like you say, Mongolia. What about their king, the empire, Genghis Khan, who had the mightiest and largest empire in the world ever seen. It extended up to Eastern Europe. Yeah, you look at that. Now, supposing they are to claim on the basis of history that those are theirs, who would agree? After all, in due course of time, they have again receded. Or, for that matter, the Greater India. The Greater India was today what you call Pakistan. You have Bangladesh. You have even a portion of Afghanistan and so many others. Now, they claim on the basis of history that they are the indigenous people. Who would agree? Time changes, power keeps changing hands, and so that is how history is. Today, I think we should be clear about those things. We will delve more into it, but we wish that people do not get agitated or rebel against the government's policies and work in cooperation so that we will have peace on all fronts and understanding.
CM has mentioned about this issue on several occasions that these four tribes has to listen to the government. So if they continue to rebel like this, is the Nagaland Legislative Assembly has the power to take away the status that has been granted to them?
The stakeholders, the tribal organizations, are the stakeholders. And we are a people's government. Our chief minister always seeks the opinion of our tribal leaders first, because Article 371A is very clear about the powers vested to our customary authorities, that especially anything to do with land and its resources and transfer of ownership is very sensitive. So the government places so much importance on our tribal leaders that every now and then we wish to confer with them on such matters. So this time we have missed the opportunity, but in due course of time, I'm sure we'll be having a detailed discussion with all the stakeholders on such matters also. What I'm saying is just more or less personal observation.
So the government does have the power to take away the status granted to them?
For such citizens, they should be cautious in their movements and cooperate with the government of the day, because government make rules and they may confer or they may deprive or they may make certain policies which may change the course of administration also. It is all at the government's.
So what is the status of the court case?
Court has issued a stay that the government not go undertake enumeration of these four tribes just now. So if that is the case, then the government has no option but to curtail all other benefits to them that has to deal with the status of this people. So, yeah, there are other things.
Push comes to shove.
If so, then the government may be forced to review whatever has been offered to them. Scheduled tribe is one, it is all right, but granting indigenous status is another. Okay.
Thank you, sir.
Sir, one last question. During Coordination Committee on IAS Induction, they just extended their, pen down strike from tomorrow. So what is your say on that?
I'm not aware of that.
They
But
just
initially
issue is
it was 3 days.
Yeah, but they extended starting tomorrow.
I see. Well, the cabinet subcommittee will meet them at the earliest possible time, and we'll try to find a solution to this amicable.
The 20th meeting will be along with them, or it is just
With
with them?
this. Boss.